Good afternoon and welcome to this webinar from EU Disinfo Lab. The title of the webinar today is Fighting Disinformation to Safeguard Freedom of Information, the Legal Obligations of Governments. Some housekeeping announcements before we get started. The registration for the annual Disinfo Lab conference is now open. The conference website is disinfo.eu/conference. And it takes place on the 15th and 16th of October in Ljubljana, Slovenia. As you've just noticed, the webinar is being recorded, and the recording will be available on our website, on our YouTube channel shortly. And you can also find all of the previous webinars there. You can also use closed captions in Zoom. For questions and answers and polls, we use slido.com. So if you've got questions, you need to use Slido rather than the Zoom question and answer. You do this by scanning the QR code on your screen or going to slido.com and entering the code disinfo. We'll start with two brief polls. Where are you joining from and which sector do you represent? You can post questions in Slido at any time, and we'll get to them after the presentation. For those of you who are less familiar with the EU Disinfo Lab, we're a not-for-profit organization gathering knowledge and expertise on disinformation in Europe. We organize these webinars to give voice to experts in our amazing community, to help knowledge sharing, and to raise awareness around the great work being done by so many in this area. The topic today is one that I personally find very interesting, which is concerns the legal obligations of governments to take action to fight disinformation as a means of protecting our human rights, in particular our freedom of information. We are delighted to have an associate professor and professor of media law Professor of Media Law and Information Society from the Amsterdam University Institute of Information Law and Leiden Law School, Tarlok McGonigal. He regularly advises and conducts studies and expert drafting work for the Council of Europe, the OSCE, and other intergovernmental organizations, and has published on the topic of positive obligations of states, not only to avoid infringing human rights, but also to take active measures when the rights are being undermined, such as by disinformation. I'll hand over to Tarlok now for the presentation, and feel free, as I said, to post questions at any time in the Slido window, and we'll come back to them at the end of the presentation. And over to you, Tarlok.
Okay, thank you very much for inviting me to contribute to your webinar series. I'm delighted to do so. And thanks very much to all of you who are in attendance today. Thanks for your interest in coming to listen to what I have to say. What you're about to witness is a bit of a high wire act. Why is it a high wire act? I'm going to try and tell a legal story to a group of people whom I realize have very different backgrounds, disciplinary wise. So some of you are hard-nosed lawyers, and others of you are coming from other areas of disciplinary expertise. So I call it a high wire act because I realize that I may end up falling short for all of your informational needs, and that means there's a long way to fall down. The other reason why I call it a high wire act is that I'm trying to do something quite complicated. I'm basically going to be taking a set of principles, basic principles, first principles, if you like, relating to freedom of expression as developed under the European Convention of Human Rights. And I'm going to try and bring them over to the other side of this high wire or tightrope to an explicitly EU context where we're dealing with the DSA and other, the Digital Services Act and other instruments which are shaping the field. So if you want to visualize all of this a bit better, you can think of the famous incident in 1974 when Philippe Petit walked on a tightrope across the distance between the then two twin towers in the US. It's the subject of a wonderful documentary, Man on Wire, and it's also the backdrop to a wonderful novel by Colin McCann, Let the Great World Spin. Now, down to the introduction. This is the overview. I've calculated that I will need 7 steps to get from one end of the wire to the other. And these are those steps. First of all, a little bit of introduction, how I approach the wire. Then I'll really go back to the basics. First, principles of freedom of expression, how the court, the European Court of Human Rights, has developed a set of positive obligations that are relevant to freedom of expression, and I will argue, to combating disinformation. Then somewhere along the way, we will cross over into the domain of the EU. I will explain what that means in legal terms. And then we'll look at the emphasis on the EU side of things. Systemic risks, they are addressed centrally in the DSA, as you all know, but I will plead for more attention to so-called epistemic risks. I think that's somewhere where we could move forward in this general discussion. Then I'll take a quick glance at some of the more recent developments at EU level. The discussions have been leading to the democracy, the European Democracy Shield, and then I'll let all of you do the hard work. I'll open it up for Q&A and discussions about, what we need to reach ultimately reach the other side. All right, so approaching the wire. I made this slide in 2017, just when the whole discussion about fake news and disinformation was getting a new lease of life. It was the in thing after the 2016 presidential elections in the US and also the Brexit referendum in the UK. We were all struggling in a foggy environment about which terms to use. In the end, through the work of Wardle and Derek Shan and the various initiatives that took place at the European Union level, disinformation largely replaced fake news as the preferred term and the term of regulatory art. So that's where we are today. And, disinformation has always been around. Fake news, it has had different appellations over time, but it's always been there. Even when the international human rights treaties were being drafted in the aftermath of the Second World War, the Cold War was in full swing. There was a lot of distrust about, other states and other states meddling in the domestic, democratic and electoral affairs of other countries. And there was a real concern about fake news, false reporting, false information, so much so that there was even an initiative to try and get that into the what became the International Covenant on Civil and Political Rights. It didn't succeed in the end, but this is just to say that this is a long-standing concern in international law and international relations. But there was something new. There were a number of different game changers which had to do with how disinformation was being created, spread, amplified, and all of these game changers ultimately had an impact on the effectiveness or the influence or impact that disinformation was having, particularly in the online environment in its latest incarnation. So to just run through those game changers quickly, technology made it much easier to create false content. The sophistication with which that was done meant that it would appear to be authentic content, maybe looking professional and therefore convincing, persuasive. The scale in which this could be done, you could reach the masses all around the globe at great speed. Then I've highlighted, for good reason, the amplification factor through algorithms and other distributive techniques and recommendation techniques. This really, really increased the impact of disinformation in its most modern incarnation. This made it a very effective form of communication, and there was great variety in the content being created and spread. It could be text, it could be online content, video, audio, you name it. So great diversity in the types of output. The permanence, once online, as the old adage goes, is always online. And now the latest game changer, and it is a big one, is what we can call Gen AIification, clumsily thrown Gen AI and a process of ification together. You get what I mean. Think of the Trump Gaza video. So all of this is contributing to much greater impact than was historically the case when it comes to disinformation, and especially online. But the good news is, as this poster in the subway in New York at the time proudly announces and reassures us, fake news is not your friend, but Facebook is working on it. So no reason for concern. Step 2, freedom of expression. Starting point is Article 10 of the European Convention on Human Rights. This is the absolute touchstone for the protection of freedom of expression in the European context. I'm not going to read the text here to you. I have highlighted a few little phrases in the text of the article, which are sometimes unfortunately overlooked, but they can be relevant for today's discussion. But just literally 2 sentences about about Article 10 generally. Look at the architecture of Article 10. First paragraph, big, broad, bold right to freedom of expression. It stretches very far, and wide and strong protection for freedom of expression. In the second paragraph, then, it's almost as if the drafters are trying to claw back some of that terrain that they've set out in the first paragraph. They're like saying, oh, well, we better not get carried away here. Freedom of expression is not absolute. There are certain cases when it can be legitimately circumscribed or limited, but they are subject to very strict conditions. So the highlighted bits in yellow, the first one is that you've got the freedom to receive and impart information and ideas of all kinds without interference by public authority. Now, the European Convention on Human Rights was drafted in the immediate aftermath of the Second World War. There was a real monopoly of power in national governments. So the big concern was that national authorities would interfere with individuals' right to freedom of expression. Now, in 2025, we're all aware that the locus of power, or at least the locus of communicative power, has shifted. And the dominance enjoyed and asserted by big tech means that they are the makers and shakers of online public debate, and interferences with individuals' right to freedom of expression typically, or at least very often, will emanate from that private source, namely the platforms. So that's relevant. We'll work around this in a moment. The second thing is I'd like to draw your attention to is the license to license, as I'd like to call it. And we see here at the end of the first paragraph that freedom of expression doesn't preclude states from licensing broadcasting, television, or cinema enterprises. We'll note that the printed press is absent from this list. It's not carte blanche. There's no carte blanche for states to regulate or license the printed press, because traditionally they've been very free to act as public watchdogs and to have editorial freedom. Why is it different for the other named organs of mass communication or channels of mass communication? Well, these were the dominant forms of electronic communication at the time. And because they were making use of limited spectrum, there was a feeling that this was a public good and they should be used in public interest, and states may have legitimate interests in ensuring that certain conditions were met. Okay, it's an open question. I think you could have a good academic argument either way about whether or not platforms could potentially fall under such a license to license. Nice juicy one for the Q&A later. The last point that I would really like to underscore concerns duties and responsibilities. If big tech is, versed in, immersed in, and preaching a different version of freedom of expression, such as that espoused under the First Amendment constitutional tradition in the US, then they're missing a really, really important element in freedom of expression as protected and developed and promoted in Europe. And that's that anyone or any actor, any corporation exercising the right to freedom of expression is governed by certain duties and responsibilities. And what those duties and responsibilities are will depend on various contextual factors, but in particular, the role of the person and the technology used. Okay, what's the relevance of all this for disinformation? Well, we see in paragraph 2 that there are 11, depending on how you count them, 11 enumerated purposes, which may make it legitimate to restrict freedom of expression in tightly drawn circumstances. And these are pressing public policy interests that may need to be defended. But disinformation doesn't feature amongst them. So here we've got a first paradox or challenge. If we accept that disinformation can cause various harms in society, at the individual level, at the group level, at the societal level, at the democratic institutional level, how do we legitimately restrict it under this key provision for freedom of expression? It's not in the list. The list is intended to be exhaustive, although some of the terms like the rights of others are open-ended. So this means that if any national authorities would seek to limit the right to freedom of expression in order to counter disinformation, they would have to somehow shoehorn combating disinformation into one of the grounds listed or purposes listed in paragraph 10.2. It's doable. I mean, you could think of the protection of public order, prevention of disorder. You could think about the protection of public health, or maybe even national security. But you gotta make that connection, and you gotta bring it in convincingly. Step 3, positive obligations. If you've read the text of Article 10 carefully, you'll see that it's primarily a negative obligation for states, an obligation of non-interference, hands off, don't interfere with the right to freedom of expression. But sometimes, very often maybe, sitting back, not interfering, not getting involved is not enough. Certainly not when it comes to making sure that the right to freedom of expression is practical and effective. There's no point in having a paper tiger with sharp teeth if it cannot roar and bite in practice. It needs to be effective. Otherwise, it's just theoretical or illusory. So in some instances, there are positive obligations on states to ensure that the rights are actually effective in practice. In respect of freedom of expression, there are 3 or maybe 3 or 4 that you can distill out of the court's case law. The first is safety and protection. If journalists, public watchdogs, someone exercising their right to freedom of expression is threatened and the authorities are apprised to those threats, they must take preventive operational measures to ensure the protection of the threatened person within their means. It must be proportionate. They have to guarantee the right to life of persons who are threatened because they're exercising their right to freedom of expression. If an attack has taken place, then there is a further positive obligation on states to investigate it in accordance with the criteria set out by the European Court of Human Rights. The investigations have to be independent, impartial, timely, thorough, effective, and so on. So that's a procedural positive obligation. The second main focus of the positive obligations under Article 10 is to ensure media pluralism. The state is the ultimate guarantor of pluralism in the media sector, in particular in respect of the audiovisual media. And that often entails taking effective measures like putting regulatory structures in place to ensure that pluralism is a reality. Pluralism doesn't happen spontaneously. It sometimes needs to be nurtured and fostered. The next positive obligation is to ensure the public debate is pluralistic and inclusive, that also minority voices, individual voices, voices outside the mainstream have their place in public debate, and that they have a reasonable opportunity to be heard. That doesn't guarantee you an audience, but it does guarantee you a certain level of access or accessibility so that you can have a meaningful forum in which to express your opinions. And this becomes very relevant in the online environment because, as we know, big tech and platforms, because of their dominance and the penetration of their services, they control who gets to access their services, and also they control the terms of debate and use of those services. So they control their gatekeepers in terms of access to online public fora, or quasi-public fora, and they also set the tone of the debate. And then the final one, and this is a further refinement of actually all of the preceding positive obligations. States have, as was recognized first in the Dinkin Turkey case in 2010, states have a positive obligation to create a safe and favorable environment in which everyone can participate and express their opinions without fear, even when those opinions go against the grain of dominant state narratives or opinions held by majority sections of society. Again, you can feel the relevance for disinformation here. Very often, the purveyors of disinformation will claim that they are minority voice, they've been excluded, and they're not been heard. So there is an inbuilt protection in the case law of the European Court of Human Rights to recognize that states shouldn't be the ones determining what expression should be allowed. States shouldn't be the arbiters of what's true or false. States, what we see in the case law of the European Court of Human Rights is actually that the court is more interested in the truth-seeking process at individual and societal levels, and not truth with a capital T as the outcome of that process. And the court, at the same time, attaches great importance to the exchange of ideas that are relevant to society. This is the argument from participation in public debate. That's really, really important. It's the lifeblood of democracy. And that's what the court sets out to protect. So it's an instrumental reading of the right to freedom of expression, so that ideas can circulate, they can be debated, they can be contested, they can be refined, they can be improved. And this should lead to individual and societal progress. So all of this is premised on a commitment to good faith communication, providing information that is accurate and reliable. I'm paraphrasing the court here. The court doesn't insist on truth. It says that information should be accurate and reliable, and it should nourish public debate. The court has also said in a 2005 judgment, Selov in Ukraine, this was a judgment that wasn't widely known until there was new attention for disinformation, and then it was propelled to stardom, so to speak. And that's because in that judgment, the court said, look, just because certain information is false doesn't mean it has to be banned. So there is a little bit of leeway there, but that should not be interpreted as saying that it's fine to publish false information. It's just a different emphasis. So it's important not to misinterpret that. We've also had more recent case law beginning of this year in case law against the Russian Federation, where various news outlets and journalists were prosecuted and convicted for referring to the war in Ukraine. Of course, that went against the official state narrative about a special military operation, and the court was having none of it. The court in Strasbourg said, no, it's not for the state to impose dominant narratives like that. Okay, so in this favorable environment, here we see the lengthier version of that quote from Dink, but I think I've discussed enough already. Step 4 is the crossover. What I've described so far are the basic principles and some positive obligations that have been developed in the context of the European Convention on Human Rights, the flagship human rights treaty of the Council of Europe. But the neighbors of the Council of Europe are the European Union, and they have their own normative architecture that protects fundamental rights, as they call them on the other side. And so the question arises: can we straightforwardly take these first principles, these positive obligations of states, can we import them straightforwardly into the EU regulatory regime? And this is where, in the middle of the tightrope, there's a little bit of sagging. But I know that at the other end of the tightrope, there's a very firm hook there, a very firm legal hook, and that's in the Charter of Fundamental Rights of the European Union. Article 52.3 says, basically, look, there's no point in reinventing the wheel. Now that we've got our Charter of Fundamental Rights at EU level, we don't need to invent everything or make it up from scratch. We're going to look to the acquis, or the established case law and principles of the European Court of Human Rights pursuant to the Convention. And insofar as there is congruence between our Charter and the Convention and that case law, we will largely follow suit. There's also a recognition that the Charter may have some additional rights, or in some respects may provide superior or different levels of protection, and that is also taken on board. So a little wobbly moment as we try to bring one set of rights and principles into another regime, but we've got over it, and let's keep going. Now, we're approaching the other side now in the EU regulatory and policy framework. As you all know, in the Digital Services Act, there are a few references to the importance of freedom of expression, and that is linked explicitly to Article 11 of the Charter of Fundamental Rights, which is an equivalent provision to Article 10 of the European Convention on Human Rights, albeit in a more modernized and a more succinct formulation. So there are those references saying that everything that platforms do, starting with their terms of use and service, should be aligned with and respect fundamental rights protection, in particular, freedom of expression and media freedom and pluralism. Okay, so these are important, at least symbolically, these are important references and recognitions. But if we have a deeper, thicker understanding of freedom of expression, we need to travel back via Article 52.3 and look at everything that's been going on at the European Court of Human Rights and see what a wealth of insights it can give us for protecting freedom of expression online. Now, I should say that the positive obligations that I mentioned there, they are binding on states, okay, not directly on big tech themselves. But in the case law of the European Court of Human Rights, there has been a lot of recognition of some of the technical and functional aspects of online expression, and how you need to take them into account when you're ensuring that freedom of expression is also effective in the online environment. And this has been developed under what's called the living instrument doctrine of the European Convention on Human Rights. And that means that even though the treaty was written and drafted in the immediate aftermath of the Second World War, it needs to be interpreted in light of present-day conditions in order to ensure that it keeps pace with societal and technological developments, and that it's in tune with the times. Otherwise, the rights that it purports to protect and promote would not be effective in the modern and drastically changed technological era. So just to give you a few examples of those principles, the internet's an indispensable source of information and a forum for communication. Internet intermediaries are the protagonists of online expression. Hyperlinks are essential for navigating vast quantities of online information. Engagement with online content, such as liking or commenting on posts of others or retweeting. All of these actions are accompanied by duties and responsibilities and can give rise to liability. The creation and control of online fora in which others can participate, this also creates duties of care, in particular for online news media and for politicians, especially regarding manifestly illegal content. So, the approach of the European Court of Human Rights is very much to set out a favorable environment for public participation for individual participation in public debate online. But what we really see in the DSA is a strong emphasis on the identification and mitigation of systemic risks within the systems controlled by the very large online platforms and very large online search engines. So that's a real difference in emphasis. And whereas on the one hand, we were talking about obligations for states, here we're talking about obligations for private actors who de facto control public spaces, quasi-public spaces. So the emphasis is on the prevention of risk and the mitigation of risk. And that is a much narrower, perhaps more negative focus than the more open approach taken under the Council of Europe system, which seeks to promote an environment in which freedom of expression can thrive and be robust and inclusive. And I think if we are to embrace this, the importance of the epistemic dimension to freedom of expression, where we should be trying to produce quality information that really does nourish democracy and public debate, then I don't think a negative focus on systemic risk mitigation is enough. I think we need to be broader and more holistic in our approach and embrace other positive measures that would flow from the positive obligations of states. One other important qualification is that the European Court of Human Rights, being a court that just determines whether there is a violation of a right or not, it's not the court's business to set out policy measures for states. The court is not prescriptive in that regard. If it were to be so, it would be very much open to the accusation or criticism of judicial activism. So the court has to limit itself to developing big principles, and then it's up to the states themselves to see how they can operationalize those principles in meaningful and practical terms. Now, this becomes very interesting in the context around the DSA because we see more recent and ongoing political initiatives at the EU level where we're moving on from the democracy, the Action Plan for Democracy, and we're moving on towards a European democracy shield. So that sounds a bit at least in terms of the choice of words, that sounds a bit like something more proactive to going back to something defensive. Let's see if what the proverbial devil in the detail has to say. These are 4 of the announced themes that will be central in the European Democracy Shield: countering disinformation and foreign information manipulation and interference, ensuring the fairness and integrity of electoral processes and the strengthening of democratic frameworks, checks and balances, including free, plural, and independent media and civil society organizations, strengthening societal resilience and preparedness, including digital and media literacy, critical thinking, etc., fostering citizens' participation and engagement. This resonates, to my ears at least, this resonates a lot more strongly with the approach that's been taken by the Council of Europe and by the European Court of Human Rights. It's about really investing in a healthy ecosystem for information, communication, media, and communication through platforms as well. So, the big question here is, we've got these high-minded principles that are supposed to offer guidance to states about their legally binding positive obligations, but we don't yet have the wherewithal to implement them in a meaningful way, to give effect to them in practice. And when I see approaches like this in the broader context or in the penumbra of the DSA, I'm wondering, to what extent can those principles carry over, and what kind of feedback would go back across the wire in the other direction, and what kind of fruitful discussions can we have? I'm going to round off now, because I'm sure there's plenty of you wanting to share your expertise and thoughts. But how do we get to the very end of that high wire that I've been treading carefully on, trying to keep my focus and balance as I went along? I think we need to discern appropriate strategies and measures. These could be preventive or preemptive measures, and there we're talking about media literacy, fact checking, all of these longer term strategies that will make for a more resilient public space in which the debate can take place. It's about empowerment, providing the tools and skills for empowerment, civic empowerment. Then we've got identification and monitoring measures. That will never be a silver bullet, but it's important nevertheless to continue to try to identify and monitor instances and especially patterns of disinformation. And one thing that comes across strongly in the DSA and in other EU initiatives is that there's a big concern, not so much or not only about the content of disinformation as it seeks to disrupt democratic processes, but also the amplification that is generated by technologies. And that's really, really relevant. Then the containing or corrective measures, what can be done to stem the tide, so as to speak. And then the key question, do you resort to regulatory or non-regulatory countermeasures? And if you are making such a calculation, I think it's really, really important to get back to those first principles that I was discussing about freedom of expression, the checks and balances that need to be in place when you seek to make any kind of limiting action on freedom of expression. But this is not to be blind to the very real harms that can be caused by disinformation. And I think there have been times, several times, I think that Western Europe has really underestimated the geopolitical dimension to the dangers of disinformation. So there I am. I'm at the end of the high wire, and maybe, as I said, when you're up there in the air, worried about falling over, it can be exhilarating. But now when you're at the other side, I wonder if it would be good to bring people back across the wire for the experience and try to see what kind of information sharing and perspective sharing we can engage in there. Thank you very much.
Thank you, Tarlak. That was very rich and informative. There was a lot of information, so thank you very much for that. There was if you have any questions from the audience, feel free to put them into slido.com and disinfo as the keyword. One of the questions, so I've two questions lined up, one of which is a fairly straightforward one, I hope, which is there jurisprudence that easily informs analysis of the obligations of states so far in relation to disinformation, particularly disinformation campaigns? And that would lead me on to a follow-up question, but I'll let you deal with that one first.
Yeah, if you're looking at jurisprudence from the European Court of Human Rights, it's important not just to do the surface scraping thing of looking for instances when false news, fake news, disinformation is used, because the court actually, without necessarily using terms as a richer tapestry of case law, where it talks about the importance of accurate and reliable information, how important that is to the citizenry in order to make informed opinion, to form well-informed opinions. And that would in turn influence electoral decision making. It's an interesting one to ask about jurisprudence specifically in terms of disinformation campaigns. That's, as the person who asked the question, as they probably identified, that's one of the big concerns at the EU level. It hasn't generated significant case law yet, but I think that would be a fascinating focus for a future case, because one important contextual consideration is, who's behind the disinformation, what is their intention, what is the context in which it takes place, and which technological means has been used, and what's the likely impact of that. So once you're talking about structured and concerted campaigns driven by bots very often, then you're into a very different corner of the ballpark. And this could be a real stress test for the right to freedom of expression, because you're dealing with content here which may or may not have been produced by AI. It's certainly been disseminated by very powerful technical means. So it's really testing the resilience of the more traditional approaches to freedom of expression. Great question, and definitely a space to watch.
I don't know if you've read the Visionum study on the Romanian election, but they describe in great detail the targeted manipulation of, among other things, a recommender system of a platform. And it could be argued that recommender systems are monolithic, and their programming is predictable, and therefore they're all by definition a single point of failure that can be exploited to undermine the existence of a favorable environment for freedom of expression. Would you, if a case were brought saying that states have failed to, this is provocative, but bear with me, states have failed to ban this threat to the favorable environment for freedom of expression, do you think that it would be more likely to succeed or to fail?
I think you'd have a very arguable case there. I mean, the European Court of Human Rights has told us time and again that freedom of expression, the right to freedom of expression, and free and fair elections are together the bedrock of any democratic society, and that permeates the jurisprudence of the court. That close linkage between freedom of expression and democratic elections. So that's a very, very strong connection. Now, I think, as I say, you could argue that case very well, because the states have a positive obligation to ensure a favorable environment. What does that mean? It's potentially very, very far-reaching. But if there is, manipulation at scale or attempts at manipulation, that's very definitely polluting the free flow of information through that favorable environment. And you could very well argue that the states should take action on that. The court, however, can only deal with the set of facts that presents itself in a given case. It cannot go off on thought experiments and exploring different scenarios. So until a case like that is brought before the court, they won't be able to engage with such a set of facts head on. But one thing I would say to those of you in civil society there, we've seen in time and again that when cases have come before the European Court of Human Rights dealing with, at the time, quite novel features of the internet, such as hyperlinks, with all due respect to their immense knowledge and wisdom, the judges are not necessarily, fully conversant in the language of technology. They may not be very tech savvy. But what you then see in those instances is when certain civil society organizations can obtain standing to make a third party intervention, they can and do very effectively explain the importance of particular technologies for the outcome of a case on freedom of expression. And it's a really important and really valuable learning curve for the judges in Strasbourg. And you often see a very close replication of the language in the third-party interventions being subsequently incorporated in the actual judgments of the court. So watch this space, and if the opportunity arises, certainly explore relevant avenues to get in on the act.
Thank you. We're getting questions thick and fast as time ticks away. So if you can try to get through as many as you can in the last 10 to 15 minutes.
To read them as well, multitasking.
Not read them, but just
I see a question there from Katie Pentney, and she's asking about systemic risks and epistemic risks. Well, Katie, of course, has also done very good work on these topics. Epistemic risks. It's hard to condense that into a short answer, but I think the substratum to public debate is a societal commitment to information that is accurate and reliable and can form a firm basis for rational, respectful, but also robust public debate. And I think strategies such as civic education, media literacy can really be important in strengthening that substratum of public debate. And it's that substratum that disinformation really, really targets. It tries to erode respect for the type of information that should be nourishing public debate. And once that starts to corrode, then it opens doors for disinformation to do its work because you don't have that same commitment. Everybody has their opinion. You don't have any shared for collective interaction. I'll go on to the next one. Anonymous hypothetical member states you fail to uphold. Yeah, the operational path, at least in path, is very difficult because of, as I said, of the two distinct regulatory systems, and that's why I wanted to open it up to the floor actually to see what kind of cross-fertilization you could have. There's a lot of emphasis in policy discussions about the multi-stakeholder nature of these problems, and I think it would be very good to have a more careful look at what the positive obligations of states might entail on the one hand, but also, how big tech and other parties are engaging with this in terms of the obligations on them. You've also, which I didn't mention in the presentation, you've also, of course, got the corporate social responsibility and the due diligence norms that are emerging in the business and human rights movement, which are really important.
Can I interrupt you briefly? There are questions coming in thick and fast, so I'll try to filter them as best I can so that you can concentrate. There's a question on the role of media regulation, which I think is your bread and butter in this fight. Do you see it as being useful? Are there levers such as news content from public service broadcasters being made more prominent on platforms? That's a topic that comes up very often in Brussels as a countermeasure.
Well, this is what I mean when I say that it's very important to have a range of measures. And I saw another question there about, if there's a negative impact by algorithms and social media, can you do something about that? Maybe I've got the precise wording wrong, but look, you can only intervene with a legal limitation when that is necessary in democratic society. And the criterion necessary isn't used lightly. It has to be circumscribed, proportionate, tightly drawn, etc. But things like promoting quality content, that wouldn't, as such, involve limiting the right to freedom of expression. If designed correctly, it would be more of a promotional measure in favor of particular types of content. And we're talking about a huge, vast, dynamic ecosystem here. And it's important then to have different policy measures and initiatives to try to ensure broader resilience of public debate through the media as well, but also through other actors.
There's a question that comes up again in Brussels, I know very frequently. Do you have any opinions on the value of different fact-checking approaches? There are some people who rely heavily on the belief that the community notes, as on X and Meta, are the solution. There was a debate in the Democracy Shield Committee in the Parliament recently, where the invited expert said that that it comes with too many hurdles to actually get the community note. I'm not sure if you have an opinion on this, or if you've done any analysis on community notes versus other forms of fact checking.
Yeah, no, others would be better qualified than me to comment on. There's lots of very good empirical research has been done on these topics. But what I would say is that, look, fact checking will never in and of itself be a panacea, but it's a very important, it has a very important function in public debate. It has its shortcomings, but it's important to continue to invest in it. What I am always worried about is when big tech themselves are coming with their own solutions on their own terms, in respect of what is already a very vertically integrated power structure, which they control completely. So, and especially the context in which X went over to community nodes and Meta as well. I think that was such an overtly politicized context that I would be skeptical about the what purpose it was really meant to serve.
Do you think that when it comes to the implementation of the DSA, that probably in line with your last slide, or your second last slide, that these the considerations that you put forward for maintaining a healthy public sphere impacts and informs the Commission's approach to enforcement of the DSA?
Yeah, well, I think the DSA is primarily focused on obligations, and I think platforms could really, really, really do an awful lot more. So what you want to achieve through, for example, the approach of the Council of Europe, is to find the mechanisms that would really seek to create an environment in which freedom of expression would be able to flourish. And that's, as I say, a sophisticated understanding of freedom of expression, a very broad, strongly protected right, but also one that is governed by duties and responsibilities of all actors involved. And that will always be a conversation. That will always be a dialogue, but there has to be commitment to that approach, that broader approach, which will also entail certain legitimate restrictions on the right.
Thank you very much. The remaining questions are all about the DSA, so I think we've covered those in the response to the last question. So I will take so the question that's just popped in: legal gaps in the area of climate change, sustainability, disinformation. We increasingly see campaigns that organize from I guess, states, but take the form of intergovernmental. I'm not sure I followed the language there. So I'll skip over.
We do unfortunately see that certain topics which may be perceived by some as controversial or sensitive, that they tend to be lightning rods for disinformation. That's not new to anyone here, but you know, it's when those topics involve things like climate change, which are quintessentially topics of public importance, then you have to take, I think, a very careful look at the disinformation and what it's the type of public discussion that is trying to curtail or stamp out.
Thank you very much. On that note, I think we've produced a lot of, you've produced a lot of very insightful and helpful information on this very difficult legal topic. So
it was very much an opening of a box. I think it would be wonderful if, not that I want to tell anyone how to do their job, but I think EU Disinfo Lab would be ideally placed to take this conversation further with, because I think it's a really important topic which can benefit from crowdsourcing and further discussion. But thank you very, very much for this opportunity to contribute. I'm very grateful also to all the participants.
Thank you very much. And indeed, it's a topic that I've been looking forward to having on our webinar about for quite a while. So thank you again. And for participants and the audience, to remind you that the recording of this webinar is on the YouTube channel of EU Disinfo Lab, and all the previous webinars are also there. We also have a newsletter which you can subscribe to also via our website. Don't forget our conference in October, and at the end you will see a questionnaire, and you have the opportunity to rate this webinar and also to suggest topics for future webinars. So feel free to let us know what you think on that. And on that note, I thank Tarlach again. I thank you, participants, for listening to two Irish accents for an hour, and I wish you a good afternoon. Goodbye, everybody.